Before I jump into what I'd like to talk about today, and today we're really going to be discussing the response by Kari Morrissey to Alec Baldwin's attorney's motion to dismiss the indictment against Alec Baldwin. So that's really what we're going to be discussing today. But before I do, I want to explain a few things. And that is, first, let's catch us up on where exactly the case is holding now and what has occurred up until this point. So what happened was, initially, Alec Baldwin was charged with involuntary manslaughter. Then those charges were dropped. They were dismissed without prejudice. Without prejudice simply means that the prosecutor has the ability to bring the charges again. So no one should feel that when charges are dismissed without prejudice that they're completely scot-free. You know that the prosecutor does have the discretion, if they find more evidence or if there's more investigation that was done, that they could bring the charges again. That's number one. So the charges were dismissed without prejudice. A number of months went by. There's more investigation that was done. And then Kari Morrissey was appointed as special prosecutor. She decided to charge again Alec Baldwin after all this new investigation and new materials became available to her. So she charged Alec Baldwin again with involuntary manslaughter. Alec Baldwin went and hired this big city law firm, the silk stocking law firm. We spoke about it in our last video, and they're now going to be representing Alec Baldwin in his criminal case for involuntary manslaughter. So you're going to have these Manhattan attorneys descend onto New Mexico and go into the court to defend Alec Baldwin in this case. Now, they did also hire local counsel, but that local counsel is just to be put on the pleadings and to do very menial tasks. That local counsel is not really going to be doing much in this case when you have all these attorneys flying in from Manhattan to represent Alec Baldwin. They're not just going to sit there silently watching the trial. So they went and they filed a motion, and the lead attorney is Luke Nikas. That's what it appears to be. Luke Nikas filed a motion to dismiss the indictment. So even though this is the second time that Alec Baldwin is being charged, they want this indictment to be dismissed. And a number of the allegations were that it was based on bad faith by the prosecutor. The prosecutor compromised, meaning they're calling out Kari Morrissey, that she compromised the grand jury proceedings. And that's why she got an indictment. But if she would have followed the court orders, if she would have followed the law, then they would have never gotten, the grand jury would have never given an indictment. And therefore, they're arguing that the entire case, again, should be dismissed based on prosecutorial misconduct and the bad faith that Kari Morrissey engaged in. So this is now going to be her response. But before we jump into the response, I just want to explain something that attorneys kind of understand, at least from my experience with attorneys, and maybe other attorneys have different experiences. But I want to explain to you an important thing to understand here. Okay? When you have these silk stocking law firms that are in Manhattan, and they're based in the big city, in the city of Manhattan, they generally don't get involved in criminal cases. They get involved with $1 million litigation. They get involved with Fortune 500 companies. They get involved with banks. They get involved with taxes. They get involved with mergers and acquisitions. They get involved with these big companies, which they're either fighting over millions of dollars or they're trying to save millions of dollars. That's really more where they belong. Okay? So there's kind of this understanding between lawyers about which lawyers belong in which playground. Okay, let's just refer to it as that. Which playground? So the playground of the banks and the securities laws and the tax law and the big commercial litigation, that's really where all these big silk stocking law firms belong, these big city law firms. Then you get down a level, you get a level to where most people hang out. You know, people have disputes, car accidents, or some smaller businesses, smaller companies have some litigation that they need to have addressed by attorneys. So then you get down into the, not so much the silk stocking law firms, you get into the regular law firms like me and you, right? These different law firms that will take on these cases and represent their clients to the best of their ability. So that's us. That's us, all us regular folk in this world. Now, what happens when you have a big firm, a big silk stocking firm from the big city, and they invade our playground? So you can imagine, you can understand now that there's going to be some tension there. They're not always appreciated because this is our playground. You don't belong here. And when they're going to come into our playground, they're going to act a certain way. They're going to have a certain sense of arrogance to them. They're going to feel like they're the smartest people in the room and they don't even belong with these lowly, petty, regular lawyer folk. So you can start to sense this from them. You can start to sense that they feel they're smarter than everybody. They feel that they're better than everybody. And you can tell it by the way they dress, by the way that they argue, by the way that they write, by the way that they even address the judge. And sometimes a lot of it's just very cringeworthy when we see this going on in our playground. Okay, so you have automatically that sentiment already present when you have Kari Morrissey, this is much more her playground, and then you have this big city attorney, Luke Nikas, and his cronies who are going to be coming into New Mexico and trying this case. So you already have, and I'm just telling you, this is the unspoken friction here, that you already have this friction here, and which is why it's going to be interesting, certainly for me, to watch this trial with the Alec Baldwin trial, because you're going to be seeing a lot of this. As you can tell how attorneys respect each other when they make arguments against each other. When it's attorneys that you are very familiar with, you know each other, you see each other every other week on a different case, there's a different type of way that you argue with them. But in this case, where this guy, Luke Nikas, is not someone who's going to be hanging out in New Mexico that often, and he's flying in on his private jet or whatever it is to come and try this case, there's already going to be some friction there. And now on top of that, he's filing this 50-page motion, which I said in my last video could have been done in probably 10 pages. And he files this 50-page motion, which is really essentially comes down to two real arguments. And a lot of the motion is basically calling out Kari Morrissey. So not only are you coming and invading our playground, now you're saying that I don't even know how to play in my playground. Okay, so you're going to already have this friction, and now the friction is doubled by this Harvard graduate attorney working at this big city law firm charging $1,500 an hour coming here and saying that you are not even doing your job right and you're acting in bad faith and you're calling her out. So you can already sense what type of response Kari Morrissey is going to be making. And as we've seen in the Hannah Gutierrez retrial, she is not someone who's just going to take something sitting down. She is going to give it right back at you. So you're going to be seeing that in this response. So I thought that was an interesting just dynamic to understand before even getting into the weeds of this case. So that's number one. Number two is that there is a stylistic way of writing your briefs. Okay, and you can really start to tell different attorneys' styles in how they write their briefs. And certainly, as I read that 50-page brief, and I pointed out some of the writings in there, how you can tell that it's more of a silk stocking law firm type of brief that they wrote it. You start to also see other different attorneys, how their approach is in writing, and really writing is it's an art, right? And writing in the legal in a court and filing briefs, it's a specific art, and everybody has their own way that they draw the picture, shall we say, or paint the picture. And there is a dispute about how to make an argument. Some people think that the argument that you're making, the judge is reading it, they don't want to hear you bickering back and forth with the other attorney, calling them out and saying how their argument is ridiculous. Just say the facts, say your argument, back it up with case law, and you're done. That's really what you should be doing. That's all the judge wants to hear. And there's a very strong position that's really how you're supposed to write your briefs. But some attorneys just can't help themselves. And they feel that they have to at least dish something back. And they have to be a little bit what I like to call snarky. They like to be like a little bit snarky with the other side's arguments. And that's something that you're going to see with Kari Morrissey's writings. Because not only is she arguing her side with the facts and the evidence and the case law and the orders of the court, but she's also being a little bit snarky, which I appreciate. I personally, because I have a little bit of a sense of humor, or maybe a weird sense of humor, I appreciate this. I appreciate when she's actually kind of like dishing it back right at them, and this is just giving us a little bit of a peek into how this trial is actually going to go down. And I'm telling you now, it's going to be very interesting to see, the Harvard graduates on one side and Kari Morrissey on the other side. So, but I'm appreciating Kari Morrissey more and more as I'm reading her writing. So with that understanding, let's get into the exact brief in which she's responding to their allegations that she essentially engaged in prosecutorial misconduct and in bad faith. So here we go. So let's go through some of the allegations that the defense team for Alec Baldwin made against Kari Morrissey. So number one, they said that she surprised him with the new charges. And she publicized it even though she said it was going to be somber and respectful. Initially, Alec Baldwin was charged with a firearm enhancement for the crime, even though that law was not even in existence at the time. They eventually dismissed that charge. She removed the 48-hour deadline from the target letter. 1 hour after being told not to talk to the press, the prosecutor spoke to the press. Kari Morrissey spoke to the press. And then when the defense team filed a motion for sanctions against the prosecutor leaked that to the press. And there was also 2 court orders, which they're alleging that Kari Morrissey disregarded when she was actually presenting the case to the grand jury. Number one, in the court order, the witnesses had to be available, meaning the exculpatory witnesses had to be available. The witnesses that Alec Baldwin wanted to testify, they have to be available. Not that Kari Morrissey has to call them, but they have to be available if the grand jury wants them. And also the jury instructions had to track the uniform jury instructions, and she decided not to say the jury instructions or repeat over the jury instructions as it is written in the uniform jury instructions. She changed it. She added things. There were only 2 days, maybe 1.5 days for the grand jury proceedings, suggesting that it was rushed through. It was a rush job. Also, she didn't tell the jury that they have an obligation to request and hear exculpatory evidence. And also, they said that she made comments that she hopes that this prosecution will humble Alec Baldwin, that it's a teachable moment, that he's arrogant. And also, the final thing that they allege that Kari Morrissey did unethically is that she was aware that the gun can fire without a trigger pull, without the trigger being pulled, and still she did not present that evidence to the grand jury during the grand jury proceedings. So here we go with Kari Morrissey's response. And it's a little lengthy, so you're going to have to hang in there, but it's very interesting, and the way that she writes, I think, is very good, and it's entertaining. So here we go. I'm not going to read everything, but we're going to go cover a number of points that she makes, and a lot of it, by the way, shows us what type of arguments and what type of evidence is going to be coming out in this trial. So it's actually going to be very telling about what this trial is going to look like. So here we go. The defendant's motion to dismiss is a predictably false, misleading, and histrionic misrepresentation of the facts and circumstances of the history of this case. So this is how she's starting off. She's starting off, they did everything wrong. Everything is false. It's misleading. It's misrepresentation. The 2 special prosecutors who have been assigned the prosecution of Mr. Baldwin have experienced near countless lies and manipulation from the defense for more than 1 year. In addition, we have and certainly will continue to be the subject of the defendant's contrived and unwarranted personal attacks. So right away saying, we're getting attacked here. We're the targets. We're actually the victims here. Baldwin and his attorneys are just attacking us, and it's probably going to continue until to the conclusion of this trial. The primary goal of Mr. Baldwin and his counsel, which now numbers 8 total attorneys, and that's something that you just love pointing out. When you're going up against a big firm, I sometimes do this also. When you're going up against a big firm and it's just you, maybe an associate, against this big firm that has 8 attorneys, it's always nice to just let the judge, oh, by the way, they have their 8 attorneys and it's just me on the other side. Let's just keep that in mind. Anyway, let's continue. The primary goal of Mr. Baldwin and his counsel, which now numbers 8 total attorneys, Heather LeBlanc, which is local counsel, she puts in parentheses, local counsel, who despite her reputation for hard work and competence, has been relegated to largely menial tasks. So Heather LeBlanc, as we spoke about, is the local counsel that these other attorneys, these big Manhattan attorneys, are going to be working with. So she is their local counsel. So really, what Kari Morrissey is kind of saying in here is that really Heather LeBlanc is completely competent enough to handle this case herself. She works hard and she's very familiar with the criminal system, criminal courts, the judges, New Mexico law, laws of evidence, things like that. She's completely can do this case on her own, but she has been relegated to largely menial tasks. All right, so she's kind of sticking up for her fellow New Mexico attorney there. Here are the other attorneys. Alex Spiro, New York. Luke Nikas, New York. John Bash, Texas. Sarah Clark, Texas. Michael Nasenchuk, New York. Jennifer Stern, New York. And Stephanie Kellman, New York, is to ensure. So after listing all the attorneys, what's the point? What are they doing? Is to ensure that the case is not heard on its merits. And if it is heard on its merits, to discredit the prosecution, investigation, and witnesses in the media so that a conviction becomes unlikely for reasons that have nothing to do with Mr. Baldwin's criminal culpability. So they are just using the media in a way to try to make this trial unfair. Continuing. She starts to give a history of the facts of this case, which is also very telling and very interesting. In October 2021, Mr. Baldwin began filming Rust on Bonanza Creek Ranch in Santa Fe County, New Mexico. Rust is a story. Listen to this. This is the first time I heard this. Maybe you've heard this before, but this is the first time I'm learning this. Rust is a story that was written by Joel Souza with participation by Alec Baldwin, and coincidentally is a story about a boy who kills a man due to an accidental discharge of a gun. Isn't that ironic? This was Mr. Baldwin's project, and the fact is clear when viewing the many video clips from the filming of the movies and interviewing the crew members. Mr. Baldwin was in charge. You look at those videos, he's the one screaming at everybody. He was absolutely in charge. Now she gets on to who Miss Hannah Gutierrez-Reed is. In true Hollywood form, Ms. Gutierrez was hired as the armorer due to nepotism. So a stab at Hollywood. I just love, I don't know, this is maybe just my own problem that I have, but I just love these little stabs that she takes at Hollywood and the other attorneys. I appreciate it. Anyway, in true Hollywood form, Ms. Gutierrez was hired as the armorer due to nepotism, as her father was a well-known armorer, gun handler, and gun coach. Many of the crew members on the set of Rust immediately noticed that Ms. Gutierrez was inexperienced and overwhelmed. Likely, and then in parentheses, you gotta love this, likely with a healthy dose of laziness and bravado mixed in. Curiously, Mr. Baldwin, the most experienced member of all the cast and crew, seems to have missed what everyone else noticed. Hannah Gutierrez was not up to the job. Alec Baldwin arrived on the set of Rust on October 12th, 2021, a week after filming began. So here's Mr. Baldwin. In I come, a week late. Everybody was here before, but I'm Alec Baldwin, so I can come whenever I want. So again, that's the picture that she's painting here. So he shows up onto Rust a week after filming began. Mr. Baldwin's late arrival on set caused him to miss the initial firearms training offered to the actors by Mrs. Gutierrez. Baldwin's late arrival made it necessary for Ms. Gutierrez to schedule a separate training session for Mr. Baldwin. So now first she has to now schedule a separate training session because he's the Mr. Special guy, and he has to now, because he couldn't do a training session with everybody else, so now he gets his own private session with Hannah Gutierrez-Reed. And then listen to this. Mr. Baldwin was inattentive during this training and spent time during the training on the phone with his family and making videos of himself shooting the gun for his family's enjoyment. So he wasn't even paying attention and listening to the training while on safety as Ms. Gutierrez-Reed was giving it to him. Upon arriving on set, Mr. Baldwin immediately began demanding the crew and the armorer work faster. Mr. Baldwin's relentless rushing of the crew on the movie set routinely compromised safety because Rust is not a romantic comedy. It is an action-filled Western with dangerous stunts and real guns being used as props. In addition to rushing the cast and crew, Mr. Baldwin was frequently screaming and cursing at himself. You just gotta love this. Mr. Baldwin was frequently screaming and cursing at himself, at crew members, or at no one, and not for any particular reason. To watch Mr. Baldwin's conduct on the set of Rust is to witness a man who has absolutely no control of his own emotions and absolutely no concern for how his conduct affects those around him. I mean, you just feel her animus, right? You just hear it coming out. All right. Ms. Hutchins was shot and killed by Alec Baldwin, who pointed a .45 caliber single-action Army revolver at her, cocked the hammer of the gun, and pulled the trigger when a scene was not being filmed and cameras were not rolling. At the time, a scene was being prepared during which Mr. Baldwin was expected to slowly pull his gun from his holster. That's all. Mr. Baldwin decided to go off script and take actions contrary to what the director, Joel Souza, instructed him to do. To the frustration of Mr. Souza, Mr. Baldwin did this frequently. He ignored direction from Mr. Souza and without warning acted on his own volition. Almost immediately after the incident, when emergency medical services were still on scene and attempts to stabilize Ms. Hutchins for flight to the UNMH Trauma Center were underway, Mr. Baldwin began preparing the unbelievable narrative that he was not responsible for the discharge of the gun and injuries to his colleagues. So here, she's also showing how right away after this accident, he wasn't concerned with Ms. Hutchins. He wasn't beside himself in grief. He was right away preparing the narrative that he was not responsible for the gun. I mean, right away, he's just caring about himself. That's what she's painting him as right now, as a selfish person. Ultimately, Mr. Baldwin arrived at the sheriff's department for a formal interview and was left momentarily in the interview room after the video recording of the interview began, but before detectives entered the room to begin speaking to Mr. Baldwin. So Mr. Baldwin's in the police station. They leave him in the room. The cameras are on. The audio's on. Everything's on except the detectives are just not there. So let's see how a person who should be beside himself in grief with what happened, let's see how he acts in the police station when he's about to give an interview. Listen to this. During this time, Mr. Baldwin, knowing that Ms. Hutchins had been critically injured and taken by helicopter to a nearby trauma center, and Mr. Souza had been seriously injured and taken to a local hospital for emergency treatment, began to make casual phone/FaceTime video calls. This is what he's doing. Instead of just being beyond himself in grief and nervous and sad about what could be possibly happening with Ms. Hutchins or Mr. Souza, he's making casual FaceTime calls. Mr. Baldwin called his wife on speakerphone or FaceTime and another personal assistant/employee regarding his family's upcoming trip to New Mexico. Why was that? Well, Mr. Baldwin's minor daughter was going to have a small part in the movie, and his family was planning to join him in New Mexico the following day. During these calls, Mr. Baldwin asked that his family not cancel the trip to New Mexico despite the tragedy. So here he is telling his family, no, keep coming to come to New Mexico. We're still going to have a great time together. This is right after somebody is dying because of your actions. He explained, I won't work and we'll go and enjoy ourselves. It's all paid for. They're not going to give us the money back. So you see, he's just caring about himself. She just keeps showing how Mr. Baldwin, Alec Baldwin, all he cares about is his own fun and his not getting the money back. Like he's caring about this instead of caring about Ms. Hutchins and Mr. Souza. Continuing. The high points of Mr. Baldwin's initial interview are highlighted for the court in State's Exhibit A. In sum, Mr. Baldwin stated numerous times, listen to this. So this is what he stated in his first interview with the police, and this is important. In sum, Mr. Baldwin stated numerous times that Hannah Gutierrez handed him the gun before the incident, and Mr. Halls never handed him the gun. So he said very clearly, who handed him the gun? Hannah Gutierrez Reed handed him the gun, not Mr. Halls. Continuing. Mr. Baldwin stated on 2 occasions that he fired/shot the gun. So he said that he shot the gun. Mr. Baldwin stated numerous times that he, referring to Mr. Souza now, was telling him where to point the gun during the rehearsal, not Ms. Hutchins. So who was telling him where to point the gun? Mr. Souza, not Ms. Hutchins. So this is what he's saying in his first interview. Mr. Baldwin never stated during his lengthy interview with law enforcement that Ms. Hutchins told him where to point the gun or gave him any instructions about what to do with the gun during the rehearsal/blocking when the gun discharged. Mr. Baldwin did state during his initial interview with detectives that the gun just went off, as he was not expecting a live round to be in the gun, but he never stated that he didn't pull the trigger. So in some points of that interview, he said that he did shoot the gun or fire the gun, and in other points he said that the gun just went off, but he never said that he didn't pull the trigger. He never said that, absolutely, I did not pull the trigger. He didn't say that in this first interview. Now let's continue. On December 3rd, 2021, after obviously having conferred with counsel, Mr. Baldwin participated in a televised interview with George Stephanopoulos, Mr. Baldwin's personal friend. So George Stephanopoulos is Mr. Baldwin's personal friend, and that's who he conducted an interview with on December 3rd, 2021. During this interview, everything changed, and Mr. Baldwin, with the aid of his attorneys, lied with impunity and blamed the incident on Ms. Hutchins. Mr. Baldwin changed his story and stated repeatedly that it was Miss Hutchins who was telling him where to point the gun and to point the gun at her. So now, who's telling him where to point the gun? Oh, now it's Miss Hutchins telling him where to point the gun. In his shameless attempt to escape culpability for his own negligence and recklessness, he went so far as to say that he pointed the gun at Miss Hutchins' armpit because that was where she told him to point it. This statement was in direct contradiction to his previous statement on October 21st, 2021, and very pointedly in direct contradiction to the portion of his October 21st, 2021 statement where he clearly explained that Miss Hutchins was struck in the armpit because she was turned to speak to someone else, not because she told him to aim the gun that way and shoot it. It was because she was turned, and that just happens to be where she was, and that's why it entered her where it did. Very notably, this is the first time that Mr. Baldwin claimed he never pulled the trigger of the gun, thereby calling into question the functionality of the gun. So now, all of a sudden, in this December 3rd, 2021 interview with George Stephanopoulos, all of a sudden, Alec Baldwin is saying that he never pulled the trigger. And now, when he says that he never pulled the trigger, what's that calling into question? It's calling into question whether you have a faulty gun here. Maybe the functionality of this gun is not right. And therefore, maybe the gun should have to be tested to see whether it just has accidental discharges. All right. On December 8th, 2021, Mr. Baldwin provided a recorded interview with Lorenzo Montoya of New Mexico, OSHA. In this interview, Mr. Baldwin's story changed again. So now we're seeing another story from Mr. Baldwin. When speaking to OSHA investigators, Mr. Baldwin told new lies and doubled down on previous lies. Again, Mr. Baldwin stated that he didn't pull the trigger of the gun, so he doubled down on that lie. In a surprising turn of events, Mr. Baldwin stated that Mr. Halls, the first assistant director, handed him the gun. So now who handed him the gun? Mr. Halls. Well, in his first interview, who did he say handed him the gun? Hannah Gutierrez-Reed. This was in direct contradiction to the numerous times Mr. Baldwin stated that Hannah Gutierrez-Reed handed him the gun when he was interviewed on October 21st, 2021. Mr. Baldwin again stated that Ms. Hutchins was telling him where to point the gun to point the gun in her direction and to cock the gun. So now they're saying that Ms. Hutchins, and now he's saying again that Ms. Hutchins was the one who told him where to point the gun and where to shoot it. So again, in contradiction to what he said earlier. As the OSHA interview continued, Mr. Baldwin's story took a very interesting turn. Mr. Baldwin vacillated between claiming that he had virtually no experience with guns and almost daily experience with guns. So which one is it? Does he have daily experience with guns, or does he have no experience with guns? So this kept flip-flopping. Mr. Baldwin stated that he pulled the hammer of the gun back, but was not going to cock the gun. So he pulled it all the way back, but he was not going to cock the gun. Anyone who has ever shot a single action revolver understands that pulling the hammer back is precisely the action that cocks the gun, thus making Mr. Baldwin's assertion contradictory and absurd. She's really going to town on him. Mr. Baldwin then made the false statement that he did not pull the hammer all the way back. So now he changed his story. No, I did not pull it all the way back. Mr. Baldwin made a truthful statement and acknowledged that the gun functioned properly and that the only problem with the gun was that a live round was in it. So now he's saying that, no, everything was working with the gun. It's just that it had a live round in it. This is what his interview with OSHA was. In sum, every time Mr. Baldwin spoke, a different version of events emerged from his mouth, and his later statements contradicted his previous statements and his attorney's assertions as set forth in their motions to dismiss. So Mr. Baldwin is just all over the place. Every time he opens his mouth, he's saying a different story. After Mr. Baldwin's interview with George Stephanopoulos, detectives became aware that Mr. Baldwin was claiming that the gun discharged without the trigger being pulled. Even though this assertion is absurd on its face, law enforcement was dedicated to a full and fair investigation, and in response to Mr. Baldwin's claims, the gun was sent to FBI for forensic testing. So now, just to cross all our T's and to dot all our I's and to take care of all of these allegations and suggestions that the gun went off by itself, even though it's absurd, we still wanted to do everything 100% by the book, leave nothing unturned, and therefore we sent the gun to the FBI for forensic testing. The FBI tested the gun and was only able to make the gun fire absent a trigger pull when the hammer was in its full resting position. Not when it's cocked, but when it's in its full resting position. This is not a malfunction, as Mr. Nikas would like the court to believe. So Mr. Nikas said that this was a malfunction, that the gun went off that it could go off without pulling the trigger, because if the hammer is in its full resting position and then you take something and smash that hammer without pulling the trigger, it can also make the gun go off. This is not a malfunction, as Mr. Nikas would like the court to believe. This is predictable and is a known consequence of the gun's design. So nothing surprising there. Shortly after the charges against Mr. Baldwin were filed, his attacks and retaliation against the prosecutors for daring to hold him responsible began. So then after all the testing came back and they decided to recharge Baldwin with involuntary manslaughter, now Mr. Baldwin started his attacks and retaliation against the prosecutors for daring to hold him responsible. This shouldn't have come as a surprise to undersigned counsel, given Mr. Baldwin's history of attacking anyone who tries to hold him accountable for his bad acts. A more complete recitation of Mr. Baldwin's history of attacks and deflection, with the aid of his counsel, Mr. Nikas, is set forth on pages 16, 17, and 19 of State's attached Exhibit D. So they have some other stories which show that anytime anybody dares try to say that Alec Baldwin did anything wrong, he immediately attacks them and retaliates against them, and then his attorney gets involved and attacks them and retaliates against them. And she's got this in some of the stories that she's attached as Exhibit D. So interesting there. In March 2023, undersigned counsel, meaning Kari Morrissey, and co-special prosecutor Jason J. Lewis were appointed special prosecutors on all Rust-related cases and kindly reached out to Mr. Nikas and Mr. Spiro to establish a civil working relationship. After some brief introductory meetings, Mr. Nikas requested that defense counsel and counsel for the state meet in person to fully discuss the case against Mr. Baldwin, and undersigned counsel graciously and naively agreed. So here, all of a sudden, March 2023 is when Jason Lewis and Kari Morrissey get involved in the case. That's when they're appointed as special prosecutor of the case. So I may have made a mistake earlier when I said that Kari Morrissey was one who decided to charge him again with involuntary manslaughter. She just got involved in March 2023. Well, let's see. So in March 2023, when she got involved, so Mr. Nikas, who's the defense counsel, right, introduced himself, and they said, we should meet in person. Let's meet in person and discuss this case. Now, very often, this is very normal for when you get involved in the case, or if you're a new attorney on the case, you got to give a call to the other attorney, let them know that you just took over the file, and talk about what's been going on with the file and discuss the different evidence and facts and arguments, things like that. And you just, you have a working relationship, which is important when you're not always fighting with each other. A lot of times, even though your attorney's on different sides, but you're still working well together. You can still do that. So this is very normal. But she said that she graciously but naively agreed. Okay, that was on March 2023. On April 12th, 2023, Mr. Nikas and his associate, Sarah Clark, flew to Santa Fe and met with the special prosecutors to discuss the case against Mr. Baldwin. During this 4-hour meeting, Mr. Nikas displayed a PowerPoint presentation that outlined his arguments against the prosecution of his client. During this meeting, Mr. Nikas stated that if the case proceeded, he may call a variety of A-list actors to testify on Mr. Baldwin's behalf, and specifically referenced Harrison Ford and Helen Mirren. So that's who they're going to call to testify on behalf of Alec Baldwin, probably to say he didn't do anything wrong. Mr. Nikas went further and stated that if the case were to proceed, he would call Mr. Baldwin's supporting actor on Rust, Jensen Ackles, as a witness for the defense. So we're going to have all these actors coming to testify on behalf of Alec Baldwin. Mr. Nikas explained that Mr. Ackles would testify that even though he personally checked his prop gun for live rounds routinely, he would not have checked it if he had been in the same position as Mr. Baldwin on October 21st, 2021. So he wouldn't have checked it. And that's what Mr. Ackles is going to testify. So we've got you. Mr. Nikas also asserted that Mr. Baldwin's position as producer on the film gave him power over creative decisions only, and that his contract spelled those limitations out clearly. So even though he is a producer, but he's only a producer in terms of creative decisions. Nothing more, meaning no more responsibility. Nearly all of Mr. Nikas' statements to counsel during the meetings on April 12, 2023 would later be determined to be false or misleading. The deadline for the defendant to list witnesses under Rule 5502 was March 1st, 2024, and not surprisingly, he has failed to list Mr. Ford, Ms. Mirren, or Mr. Ackles. So all these A-list actors, which Mr. Nika said, we're going to have them testify on behalf of Alec Baldwin, and they're just going to destroy your whole case. They're not even listed on the witness list. And by the way, not everyone that you list on the witness list you have to call. So they're not even listed on the witness list. In fact, undersigned counsel, meaning Kari Morrissey, actually recently contacted Mr. Ackles and was notified that no one from Mr. Baldwin's defense team has ever reached out to him and requested he testify on Mr. Baldwin's behalf. Now, does this have anything to do with the actual underlying issue? No, but she's also setting up the whole course of how she's been dealing with these attorneys and Mr. Baldwin, and how you see that they're completely disingenuous about everything and they can't be trusted. Mr. Nikas intentionally made numerous false statements in his motion to dismiss, but one of the most shocking is his assertion that the defense proved to the state that the gun used by Mr. Baldwin was modified. That never happened. Mr. Nikas contacted undersigned counsel and specifically requested she consider dismissing the case against Mr. Baldwin without prejudice while the forensic testing took place to ensure that Mr. Baldwin did have to bear the expense of paying his numerous elite attorneys to defend him at the preliminary hearing, only to later have the case dismissed if the forensic testing indicated that the hammer of the gun had in fact been modified. So here you have Mr. Nikas. Mr. Nikas is telling Kari Morrissey, look, we think that there's a problem with the gun, where there was an accidental discharge. And therefore, let's not have all of this attorney time during a preliminary hearing where Mr. Baldwin's going to have to pay us $1,500 an hour, whatever he's paying him, and all of these attorneys, so that's times however many attorneys show up for the preliminary hearing to take notes or to bring coffee at $1,500 an hour, whatever. So let's spare the cost for Mr. Baldwin, because if the forensic testing comes back and it turns out that this gun could have an accidental discharge, well then we just wasted all of Mr. Baldwin's money paying all of these elite team of attorneys for nothing. So here's Mr. Nikas telling Kari Morrissey, let's just dismiss it without prejudice. You can bring it again. Just dismiss it without prejudice and wait to see what the forensic testing is going to come back. And if it comes back that it could have been an accidental discharge, well, then we can have another conversation whether this case is going to go forward or not. So actually, I was right the first time. Kari Morrissey was the one who dismissed the case. Undersigned counsel agreed to dismiss the case without prejudice, pending the outcome of the forensic testing and the resolution of outstanding discovery issues related to Mr. Baldwin's producer contract and other items in the possession of Rush Productions. So Kari Morrissey said, okay, fine, sounds good. We're going to do the courtesy to Mr. Baldwin. It's like she's showing how she's bending over backwards to accommodate Alec Baldwin and his attorneys and his elite team of attorneys who are just really concerned about how much money Mr. Baldwin's going to have to pay them. Mr. Nikas asserted in his motion to dismiss that Mr. Baldwin was somehow shocked and surprised by the refiling of the charges against him. This is patently false, given that the agreement entered into between Mr. Nikas and the undersigned counsel was that the case would be dismissed without prejudice pending the outcomes of the forensic testing on the firearm. All Kari Morrissey's agreed to, this is what she's saying, this is no surprise to Baldwin. Oh my gosh, you're charging me. How can you surprise me with such an announcement? This wasn't a surprise. I told you before. We're only dismissing it without prejudice pending the outcome, the results of the forensic testing. And now that the forensic testing came back that it was not an accidental discharge, well, now we're going to charge you again. Yeah, that was the deal. So don't pretend that this was some sort of surprise. Okay. It was now October, skipping ahead a little bit. It was now October 2023, and the case was finally ready to be refiled. As disclosed in Defendant's Exhibit 4 to his motion to dismiss, counsel for the state gave Mr. Baldwin the option of accepting a very favorable plea agreement, rather than have the case proceed to grand jury for a possible indictment. So here now we have Kari Morrissey is saying that she actually extended a plea deal, a very favorable plea agreement, to Mr. Baldwin. Instead of going through the grand jury indictment, instead of being indicted for involuntary manslaughter, she offered them a deal. Counsel extended this plea offer reluctantly, but did so with the intention of ensuring that similarly situated defendants do not receive disparate treatment. So she wanted to show everybody's the same here, whether you're Alec Baldwin or somebody else. I want to show that everyone's going to be treated the same. So just because you're Alec Baldwin doesn't mean that you don't get a good deal just like everybody else I would offer to. So here is the offer. I'm giving it to you just like I'd give to anybody else. Mr. Halls was offered a favorable plea, and it seemed only fair to extend a similar offer to Mr. Baldwin prior to proceeding to a grand jury presentation. So Mr. Halls accepted that deal, as you recall from the Hannah Gutierrez retrial. So now she made the same offer to Mr. Baldwin. Prosecutors are certainly not bound by the philosophical notion that all similarly situated criminal defendants must be treated similarly, but undersigned counsel is not a career prosecutor. Rather, she is a career defense attorney and civil rights lawyer. She's a special prosecutor, meaning she doesn't do she's not a regular prosecutor. She's actually a defense attorney. And she's also a civil rights lawyer. A lot of times they go together. And therefore, she believes strongly in issues related to fundamental fairness. Undersigned counsel has learned some tough lessons about the consequences of her idealistic notions during her dealings with Baldwin's counsel, and the series of events that unfolded as a result of the plea offer have been the toughest lessons learned to date. So she learned her lesson. Essentially, she's saying, I learned my lesson that, yes, I should deal with Baldwin and his counsel differently than I deal with other criminals. On October 5th, 2023, the special prosecutors extended a plea offer to Mr. Baldwin as confidential and privileged plea negotiations and gave Mr. Baldwin until October 27th, 2023 to accept the offer, or the case would proceed to grand jury on November 16th, 2023. So they offered a confidential and privileged plea negotiation. So they gave them this confidential deal, which means this should remain confidential, right? Well, let's listen to what happened. Counsel for the state received no response at all. So we didn't receive any response. We sent you to this in an email. Well, it doesn't seem it was an email, but she sent it to them, and no response at all. Not even an email from defense counsel stating that they received the offer and would discuss it with their client. So normally when you get an offer as an attorney, you say, okay, I'm going to discuss that with my client and I'll get back to you. Approximately 10 days after the offer was extended, and well before the deadline for Mr. Baldwin to accept the offer, undersigned counsel received information that Mr. Nikas provided all the details of the presumed confidential and privileged plea offer to a reporter with NBC News in New York. So this is after Kari Morrissey gives them a confidential offer, plea agreement. They go and tell all the details of the plea agreement to NBC News. After determining that the reporter did indeed have all the details of the plea offer extended to Mr. Baldwin, undersigned counsel received, anytime she says undersigned counsel, she means herself. Undersigned counsel received additional information that Mr. Baldwin and his counsel were working with the media to generate a campaign designed to deflect attention away from any future plea hearing to protect Mr. Baldwin's public image. Counsel received information that Mr. Baldwin may accept the plea offer, but intended to file a civil complaint against the state of New Mexico and the former prosecutors on the same day as the possible future plea hearing to direct media attention to the frivolous lawsuit and away from the plea hearing. So they orchestrated an event to kind of shift the focus, the media focus, off of this potential plea hearing where Alec Baldwin may plead guilty to something, a lesser charge, and instead of that, so at the same time, they had this other lawsuit filed to divert the attention away from the media from the plea deal or the plea hearing. As disturbing this information was, undersigned counsel was not inclined to rescind the plea offer simply because Mr. Baldwin intended to continue to use the media to escape the consequences of his actions, and his counsel had flagrantly disregarded the privileged and confidential nature of plea negotiations. So, even though this was so disturbing, what was going on to Kari Morrissey, even though this is so disturbing, she's still not going to rescind the plea offer just because you're not acting appropriately. I made the offer was in good faith, and therefore I'm not just going to rescind it, take it back, just because you're not doing what you're supposed to be doing and you're not keeping it confidential, or you're not acting respectfully. So she's saying that even though you're not acting respectfully, still, I didn't rescind the plea agreement yet. Next, undersigned counsel received information that Mr. Baldwin commissioned his own documentary about the death of the woman he killed. And he was actively pressuring material witnesses in the case against him to submit to interviews for his documentary. It was at this point that the plea offer was rescinded. So at that point, I had enough. That's what Kari Morrissey is saying. I had enough with these games. We're not doing this anymore. The plea is off the table. And the case was scheduled for grand jury. And still, Mr. Baldwin complains to this court that he has been treated unfairly. If anything, she's showing he has been treated much more than fairly. We are bending over backwards for him. It is worth noting that after the plea offer was rescinded, the NBC News reporter again contacted undersigned counsel and warned her, listen to this, that she, the reporter, spoke to Mr. Nikas about the retraction of the plea, and Mr. Nikas explained that he was going to destroy undersigned counsel, meaning he was not so happy, he was so upset about Kari rescinding Kari Morrissey from rescinding the plea agreement, that he is going to destroy her. That's what he told her. And this is what she's saying. Undersigned counsel responded that she expected nothing less. Okay. All right. In his motion to dismiss, Mr. Baldwin complained about counsel's contact with an NBC reporter on November 15th, 2023. In truth, the sole reason undersigned counsel had any contact with the reporter is because Mr. Baldwin's counsel released to NBC News all videos from the filming of Rust that they requested to be provided to the grand jury as exhibits in the grand jury alert letter. So defense counsel was the one who started going to the media. And now you're complaining that the prosecutor went to the media after? Defense counsel released the videos to NBC the night before the grand jury was scheduled to convene and modified the videos to show their client in a more favorable light. Undersigned counsel did not provide the January 2023 grand jury date to anyone other than the witnesses being called before the grand jury and instructed those witnesses not to disclose it to anyone. So I followed every order. I didn't violate any order of the court. That's what Kari's saying. I didn't tell anybody about the grand jury date. The only thing that happened is that you, defense attorney, you went and leaked all of the videos and changed them and modified them to make your client look like he didn't do anything wrong. The meat of Mr. Nikas' arguments related to the presentation of the charges to the grand jury demonstrates, you just got to appreciate this. All right, here we go. The meat of Mr. Nikas' arguments related to the presentation of the charges to the grand jury demonstrate a fundamental ignorance on the part of Mr. Nikas with regard to the law as it relates to grand jury proceedings in the state of New Mexico. There's nothing more enjoyable than pointing out the ignorance of a big city attorney who's coming in trying to show that he's smarter than everybody else. There's nothing more enjoyable, and I assure you that this was probably one of the most favorite parts of Kari's when she was writing this brief. So again, the meat of Mr. Nikas' arguments related to the presentation of the charges to the grand jury demonstrate a fundamental ignorance on the part of Mr. Nikas with regard to the laws as it relates to grand jury proceedings in the state of New Mexico. Now, for good reason, because most likely Mr. Nikas has not been in criminal trials. He's probably been dealing with banks and dealing with art and other types of high stakes litigation, not criminal cases. So it makes sense that he doesn't know what he's talking about, but she just wants to point it out and make it very clear that he doesn't know what he's doing. It's always more enjoyable. So first, the presenting prosecutor is not required to notify the grand jurors of their ability to subpoena witnesses or documents. This is the purview of the court. So this is not my job. You're saying it's my job, and I had a duty to tell the grand jury that they have a right to hear other witnesses and subpoena other witnesses and other documents. No, that's not my job. That's what the court's job is, sir. The grand jurors don't walk off the street and sit down in the grand jury room with no information about their powers. The grand jurors go through a formal orientation where they are verbally notified of their ability to subpoena witnesses and evidence, and they are provided with a written packet that instructs them of their powers. The written instructions provided to the grand jury by the court clearly state the presiding judge of the grand jury will guide you to assure that your actions are within the authority conferred upon you by law. Any grand juror may, at any time, with propriety, seek advice and guidance from him or her as to the scope and propriety of the grand jury's acts and investigations. The grand jury has the power to order the attendance of witnesses. So this is what the judge told them. You want me to tell them? You want the prosecutor to tell them? That's just showing your ignorance of how this works. The grand jury has the power to order the attendance of witnesses and to cause the production of public and private records or other evidence relative and relevant to its investigations. It has the authority of this court to subpoena witnesses and to obtain execution of subpoenas. Not only did the state read every word, now here she's moving on to another part. Not only did the state read every word of Mr. Baldwin's alert letter to the grand jury, because they were complaining about that also, but the state also provided each and every grand juror with their own copy of Mr. Baldwin's alert letter. Even though the alert letter provided to every grand juror detailed the documents Mr. Baldwin requested the grand jury consider, the state had copies of each and every document for each grand juror in the room. There were 3 bankers' boxes of documents sitting in the room. And at the conclusion of the evidence, undersigned counsel notified the grand jury that copies of all of Mr. Baldwin's requested documents were available for their review should they wish to be seen them. So we got all these bankers' boxes of documents. These are all documents that are all available for you. If you want it, just say the word, we'll give it to you. And none of the jurors asked for them. So we didn't do anything wrong. The state provided Mr. Baldwin's requested proximate cause instructions, read the instructions to the grand jury verbatim, and included the instructions in the packet of instructions that the grand jurors were required to consider. Mr. Baldwin complained in his motion that the state didn't take enough time to present the case to the grand jury and rush through the presentation. Now remember this part. This part was that they said he only spent a day and a half to present the evidence to indict Mr. Baldwin. Isn't that's a rush job? Their commission was going to end. The grand jury. Their grand jury subpoenaing or summoning that was going to end, and you just rushed it through in 1 day or day and a half. Now listen to this. This is great. Mr. Baldwin complained in his motion that the state didn't take enough time to present the case to the grand jury and rush through the presentation. This assertion is absolutely false, and another attempt by Mr. Baldwin to receive special treatment. The state spent 1.5 days presenting this case to the grand jury. This is an unprecedented amount of time to spend presenting any case to a grand jury, let alone a 4th-degree felony. So let's understand this. This is a 4th-degree felony. This isn't a 1st-degree murder case. This is a 4th-degree felony. Okay? A day and a half is more than enough to provide evidence. And listen to this. It gets even better. The Baldwin grand jury presentation was likely one of the longest in New Mexico history, and almost certainly one of the longest in the history of the First Judicial District Court. The grand jury presentation was unusually long because there was a great deal of evidence, witnesses, and exculpatory material that needed to be presented. Upon reading the laughable assertion that 1.5 days was not long enough, undersigned counsel gathered information from prosecutors in the 2nd Judicial District, which is considerably greater in population and crime rates than the 1st Judicial District. So she says, you know what I did? I went to the 2nd Judicial District. I spoke to a bunch of prosecutors, and they have many more people, many more crimes. And let's see what they had to say. She spoke to 2 prosecutors who routinely indict and prosecute capital murders, child abuse resulting in death, child molestation cases, and adult rape cases. And both prosecutors reported, listen to this, that the longest grand jury presentation they have ever participated in. Guess how long? If I had to ask you, all of you, how long do you think the longest grand jury presentation for these capital murder cases, or child abuse cases, or child molestation cases, or adult rape cases, how long do you think the longest time for a grand jury would be? Take a guess. And listen to the answer. Lasted no longer than 3 hours. Okay? 3 hours. And this case, this 4th-degree felony, took a day and a half. Okay. Mr. Nikas complained in his motion that the prosecution rushed through the grand jury process and should have postponed the grand jury presentation, and simultaneously complained that the charges have been hanging over Mr. Baldwin's head for far too long. So at the one point, you want everything extended because we're rushing too fast. And on the other hand, you're complaining that, oh, these charges have been hanging over his head for so long. Well, make up your mind. Do you want things to go faster or do you want things to go slower? There is simply no pleasing Mr. Baldwin or his counsel. And then he says, Mr. Nikas is incredibly articulate and very persuasive, and he probably is. But he is certainly not devoted to truth-telling. Mr. Nikas also demonstrated his ignorance of the rules of evidence as they pertain to grand jury proceedings. And again, this can be understood because how often do you think he's involved with grand jury proceedings or knows anything about them? But still, she wants to point it out. Mr. Nikas also demonstrated his ignorance of the rules of evidence as they pertain to grand jury proceedings and criticized the state for presenting its investigator, Connor Rice, to testify as to hearsay related to the investigation and the incident. So he complained that some of the testimony was all hearsay. And we all know the rule of hearsay, don't we? Well, listen to this. Hearsay is permitted in grand jury proceedings. All right? And during most grand jury proceedings, the state calls only one witness who testifies largely to hearsay learned from other sources. So grand jury proceedings have a different rules of evidence than a regular trial. Mr. Nikas complained on page 35, paragraph C of his motion, that the special prosecutors issued an improper and prejudicial instruction to the grand jury. Remember, this is one of his arguments, that they changed the jury instructions. This is patently false. The prosecutors did not deviate from UJI 14-231, which is the uniform jury instruction. We simply filled in the language that was required to be filled in and did so in accordance with the instruction and the facts presented to the grand jury. So we didn't change the jury instruction like what you're trying to say. Just the way that the jury instructions are written is they're not specific for every case. They don't talk about your case. They talk about in general, right? This is the uniform jury instructions. So it says at certain points, fill in blank here. And you're supposed to fill in the blank and talk about your case, whatever facts are relevant to talk about your case. And that's all that they did. And now, with respect to the other complaints, that the witnesses were not even available. And that was the court order, that the witnesses have to be available. The grand jury did not elect to hear from Baldwin's witnesses, and if they had elected to hear from them, they would have been presented in person, virtually, after seeking and obtaining approval from the court, or via video recorded statements they previously provided to law enforcement in pretrial interviews. So, were they available? They were not sitting outside the courtroom, but we could have made them available. We could have called them, they had statements that they were given, or we would have arranged for it to happen. So that's also considered available. And therefore, after all of this, Kari Morrissey says that the motion to dismiss the indictment should be denied. All right, well, that's it for now. Thanks for watching. If you haven't yet, please subscribe, like, and we will see you next time.